everyone. My name is Sigal Barnes, and I'm an attorney here with Lawline. First and foremost, I want to thank you for choosing to watch this program. So you're probably asking, why are you seeing me in the Lawline studios before the program? The reason why is because I wanted to personally tell you what we're doing with these kind of programs. Although Lawline is a nationwide provider of CLE, one of the things that we're trying to do is, in addition to providing nationwide interest programs, things on a federal level, as well as, state level things, we're also trying to provide a lot more content on a local level. Local content is just as important to us as the federal and the larger state level issues. And so this program is one of those programs that is actually in direct response to customer and subscriber requests, both to learn a little bit more about how the bike law industry is affecting New York, and as well as how the bike law industry is affecting various industries within the New York area. So please, if there is something within your local area that you're looking for, feel free to contact us. Let us know what issues are important to you, both on a nationwide level as well as a local level, and I hope you enjoy this program. Thank you.
First of all, in terms of the audience, who here rides a bike? Okay, and in terms of everybody here, anybody commute on a regular basis on bike? Excellent. Anybody else? Just one? And what's a major reason why a lot of you choose not to commute by bike? Is it safety? Is it distance? Safety is a big issue, right? All right. Interesting enough, those of you who are kind of into the cycling movement, New York City was just rated #1 by Bicycle Magazine as the #1 bike city in the nation. A little surprised to hear that, right? Yeah, they didn't do it based upon safety. If you notice, living in New York City since 2007, we've had an increase in 350 miles of bike lanes since Khan has become the Commissioner of Transportation. We've seen a massive growth of infrastructure. There are bike lanes, there are bike lights. You now see an intersection, designated turn hours for bicycles. It's a huge increase and a large growth in a very, very short period of time. And it's amazing it took this long to get there, because the reality is what you're seeing are gallons and gallons of paint, right? And it's relatively cheap. And there's no reason why this can't be happening everywhere in the country. And it slowly is. The movement's growing, and people are starting to realize that it's a great alternative method to get to work, to get to the market, to transport your kids to school. But that being said, I'm here because it's still not safe. And if you're practicing in New York, anybody here do personal injury litigation? One? Okay. Me personally, I have a general personal injury practice, and I have a focus now. It's almost 50% of my practice is now specialized or focused on bicycle crash litigation. And I'm practicing everywhere from as far east to Suffolk County to Riverhead, and as far north up to Westchester. And the interesting thing about that Bicycle Magazine article that came out last month is, in that article, they had both the best bicycling city in the country and the worst. And ironically, the worst cycling city in the country is actually Suffolk County, New York. So some 50 miles east, in a jurisdiction where all you are going to be maybe practicing, and I think I have the stat up here. Let's get to that. And they found Suffolk County to be the worst cycling location in the country. Now, what's going on in New York City before we talk about Suffolk County? Right now, we have some 36,000 bicycle commuters on a daily basis. That's huge. It's 1% of the commuting population of New York City are now commuting by bike. You add to that another 6,000 city bikes, assuming all 6,000 are on the road, because right now that's an issue. There's about 1,000 in the repair shop. But you have another 6,000 bikes. And then on top of that, you have an unknown number of recreational riders, either riding along the Hudson Trail or just going out for a daily bike ride. So, it's a huge amount of cyclists that are on the city streets, and they're sharing the roads with cars, taxi cabs. So it's still a dangerous environment. And in fact, I think this month, despite all the inflation and the focus on Vision Zero, this past month was the worst month this year so far for cyclists and pedestrian fatalities in the city of New York. So despite the speed zone cameras and the focus on Vision Zero, not enough is happening yet. So why is Suffolk County so much different? So Suffolk County, get to that slide, in 2008 had 23.8% of all cycling fatalities in the state of New York. That's huge. It's a big county. I think there's about I'm not sure, don't hold me to it, around 3 million people living in Suffolk. It is less than 1% of people in Suffolk County commute by bike, but it has the largest number of fatalities. I think a lot of that has to do with infrastructure. Again, going back to why New York City is getting better and safer, we have painted bike lanes, we have designated bike lanes. Suffolk County doesn't have that, or they have very little of that, and there's very little funding in bicycle infrastructure. I think the other big issue that I see, because I ride all over the state, New York City's grown to learn to accept bikes on their roads. People might not like it, but a driver is not surprised when he or she sees a cyclist sitting next to them in a light on Fifth Avenue. Out in Suffolk County and in the suburbs, they're still not used to it. Seeing bikes and cars on the service roads of the LIE or on urban roads is still new to cars, and they don't know how to deal with that. I think the best way to start to alleviate some of that problems in Suffolk County is by education. And I serve on the board of directors of the New York Bicycle Coalition, and one of our big projects this year is to start to educate cyclists and cars, both drivers and cyclists, about the laws of the road and how to share the road. Anybody here remember everybody's license or have a license in New York State, driver's license? Majority of you? Anybody know how many questions there are right now on the New York State driver's license exam about cyclists? Anybody have a guess? 1. It's scary, right? That a 17-year-old kid who's getting his license for the first time is being taught one single question or has one single question on an exam that's going to give him a 3,000 or her 3,000-pound vehicle, and a cyclist can die. So there needs to be a change in education in New York State, like all over the country, with regard to educating motorists about how to share the road with a car. Any of you familiar with the 3-foot rule? Okay, California just passed a 3-foot law. And what that is that a motorist cannot pass a cyclist less than 3 feet. So they have to give every cyclist that they pass at least 3 feet of passing room. It's not a lot of space. New York State doesn't have that law. It's a controversial issue whether or not it can be enforced in New York. It's difficult to enforce because police officers don't have a ruler. So it's kind of an objective position of whether or not somebody's 3 feet or not 3 feet. But I think it's a good start. And one of the things we're working on is trying to bring that law to the state of New York. All right, so let's talk a little bit about bike law. It's kind of a fun topic, right? You know, it's something you did as a kid. Now you get to grow up and be a grown-up and be a bike lawyer. I don't know any Barbie lawyers or Lego lawyers, but this is kind of as close as I can get. And what's neat about cycling law is it brings a lot of different issues that you would deal with in any general personal injury case to the forefront. One big issue is always insurance. And the biggest issue we're going to talk about, or it's going to be one of the bigger issues for your clients. And it could be a whole separate lecture. I can't cover it all today, but that's no fault. Another crazy issue, which sounds nuts, but I have clients that come to me who have a broken leg, might have surgery, it's still in the hospital, and one of the first questions they ask me, who's going to pay for my bike? All right? They're riding a $10,000 Cervelo, and they are pissed that their bike got wrecked. All right? They can care less about their leg. So we're going to talk a little bit about property damage and how to calm your client down about that a little bit. We're going to talk about property damage, she said. We're going to talk about some premise liability and municipal liability, which is a little bit unique as it comes to cyclists. And each one of these issues, even products liability, which I'm not going to cover today, but that's going to come into a bike crash case as well. So first thing we're going to talk about is PIP coverage or no-fault coverage. All right, so generally what no-fault coverage is a way to help your clients get their medical bills paid or their lost wages paid. It's also really critical for people who are self-employed. A lot of my clients are web designers, artists, people you typically find riding their bike, and they don't have health insurance. Well, you know what, now with Obamacare, it's a question of what their level of health insurance is. But again, getting their medical bills paid is going to be really, really critical. Liability insurance with regard to the car that struck them, and sum insurance. Does your client have it, and is it available? Let me spend a little bit of time talking about sum insurance, and which is the last item down there. It's called supplemental uninsured motorist coverage. It's also known as uninsured motorist coverage. And every single one of my clients and anybody here who rides a bike in New York State and also owns an automobile needs to go home tonight or today and check their auto policy and look at what their sum coverage is. I lecture at a lot of bike clubs, and this is one of the first things I talk about is sum coverage. So let's talk about sum coverage first. Sum coverage is what's known as supplemental uninsured motorist coverage. And that is a policy on your own auto policy that covers you or anybody who resides in their household if you're involved in a crash with a car that has the minimum amount of insurance in New York State. So right now, a person can be driving a car in New York State with $25,000 in coverage. And whether or not that person kills somebody or sprains a neck, the most that person is going to be able to collect, unfortunately, from even a death case, is going to be $25,000. That's the minimum in New York State right now. I think that's a crime, but that's where we are with this right now. Supplemental uninsured motorist coverage is your own policy where you could turn around back to Allstate, Geico, whoever your carrier is, and say, look, I just got hit by a guy who's got the minimum amount of coverage. I want to turn around and make a claim with my own carrier for what's called supplemental uninsured motorist coverage. And if you look at your policy, you could have 100, 300. I have $1 million. And it's incredibly cheap. And that's why I tell people, if you're buying liability coverage, which normally costs somewhere, I'm not going to say a quote on your policy, but the difference between uninsured motorist coverage is another $100 a year. It's incredibly cheap versus the benefit that you get. So if this person strikes me and has $25,000 in coverage, and I collect that $25,000, I could then turn around to my own carrier and make a claim for the underinsured motorist coverage. And there's a set-off, okay? So if I have $100,000 in coverage and I collect 25, I could then turn around to my carrier and collect, if I have 100, there's another $75,000 available. If I have $1 million, there's $975,000 available, all right? But imagine a situation where you get struck by somebody and you're laid up in a hospital bed for 2 months, you're out of work, your loss of enjoyment of life is gone. If you loved riding a bike, you love spending time with your kids in the park, spending time with your friends, you're not doing that. And the only thing you have available to you is $25,000 from the car that hit you, you're going to be very, very happy that you have this coverage, the underinsured motorist coverage. Uninsured motorist coverage. Anybody here believe there are people driving around cars with no insurance? Yeah, and I see it way too often. MVAC is another way to go. It's a lousy way to go, and I'll explain briefly what that is. MVAC is the Motor Vehicle Accident Indemnity Corporation, which is a fund. They're actually down here on Beaver Street. It's a fund set up by the state of New York. It's funded by all the insurance companies in the state. And if you're involved in a crash with somebody who has no insurance and you don't have coverage, which I'm going to talk about in a second, you could turn to MVAC, which is a state agency, to file a claim and make a claim up to $25,000 with MVAC. MVAC is a pain in the butt. MVAC requires that you report the crash to the police within 24 hours, and you require leave of court to sue MVAC. So you have to jump through a bunch of hurdles to get to MVAC. And then when you get there, MVAC will never pay their full 25 policy. It can be a death case. It could be a horrible injury case. And MVAC knows that the attorney and that client, it's going to cost them more to try that case, and there's no bad faith. Meaning if I hit MVAC on trial for $1 million, I could still only collect 25. All right? So I know if to go to trial against MVAC, it's going to cost me minimally $5,000 to bring a doctor into court to testify. So MVAC knows that, and there's no bad faith against MVAC, so the most they're going to offer you is 20. It's a really messed up system, and you don't want to go there unless you have to. The alternative is uninsured motorist coverage. And similar to sum coverage, or the uninsured motorist coverage, this is turning around to your own carrier and making a claim for uninsured coverage. And that uninsured coverage, again, could be at any level that you buy. So you could have uninsured coverage for 25, 50, 100, or $1 million. And they usually are concurrent. So if you have some coverage for $1 million, you have coverage for $1 million. And it's a really, really important policy, and incredibly important if you bike in New York. Okay, so no fault. So no fault is a system set up, God, I think it's sometime in the 70s when they first came out with it, and it's been different versions of what existed. Initially, it was a minimal financial amount that you had to collect in order to prove a serious injury. But what no fault is a system for you to get paid, your client to get paid medical expenses and lost wages, despite the fault of the crash. All right, so if your client is struck by a car, that car's no-fault policy provides up to $50,000 in benefits for your client's medical treatment, physical therapy, emergency room treatment, ambulance, all the expenses that can come out of a crash. This is separate and apart from any lawsuit. This is the initial claim that's made with regard to getting benefits for your client. People are scared. If you have young students, if you have newly young working people who are afraid that a bike crash and a trip to the hospital is going to bankrupt them, this is their assurance that's not going to happen. And this is why this is actually probably the primary reason why people contact my office. Because a lot of people say, I'm going to go at my own, I'm not so badly hurt, or maybe they just don't want to bring a lawsuit, but they still haven't figured out the no-fault system. And no-fault is very, very difficult to navigate if you don't know what you're doing, and especially if you're dealing with an insurance company that's not a friendly insurance company. I'll give you an example. American Transit Insurance Company, which insures 90% of the cabs in New York City, is horrific. Okay? Despite their driver being at fault for the crash, everything you do with that claim, from no fault to liability, is going to be difficult. So you're going to be providing some guidance to your clients about no fault. And that's a slide about no fault. And what it covers, like I said earlier, is going to be medical expenses, lost wages. It covers travel expenses to and from the doctor. So if you have cab receipts for your clients, they're going to be reimbursed by no fault. All those things are going to be covered under the no fault policy. So how do you attain no fault for your client? Well, the first thing you want in any early investigation in any bike crash is a copy of the police report. Because on that police report, we're going to be able to identify the driver, the insurance company, the registered owner. All that information is going to be on that report. On the insurance report is going to be a 3-digit code, which is going to tell you who the insurance company is. The most critical thing to do is to report the claim within 30 days of the crash. All right? So in order to take one of the prerequisites to no fault is reporting the claim to the insurance carrier within 30 days of the accident. You have to make sure also that your client is not billing or telling any doctor to use their private health insurance. No fault becomes the primary source of medical coverage. And a lot of people get stuck with bills because they give the hospital, they give their doctor their private carrier. As soon as the private carrier sees one single note that it's related to a car crash, the first thing they're going to do is deny the claim. And there's a requirement in no fault that the doctor's bills be submitted within 45 days of the accident. So you want to make sure that the clients are using no fault as their primary source. Now, that 30-day rule, it's pretty strict, but there are circumstances where you can get around it. If you have a client who's hospitalized for more than 30 days, wasn't in a position to avail themselves of the police report or obtain the insurance information, they were disabled, death cases, a lot of those scenarios create an avenue to get outside that 30-day filing requirement, but you don't want to get there. So if you can get the information as soon as possible, this no-fault system is set up to be a friendly, I laugh when I say it, but it's supposed to be an environment where if you don't rise to a level of injury in New York State, if you don't sustain a serious injury, you can't sue a driver for a crash, okay? That's the initial concept of no fault. So no fault was set up saying, we're going to make sure if you're involved in a crash, your bills are taken care of, your bills are taken care of, your lost wages are provided, all those things are taken care of. And if you want to sue that driver above and beyond no fault for your injury, you need to prove that you sustained a serious injury. And the law defines serious injury as death, fracture, disfigurement, or a significant limitation of a use body organ member function or system. So that was the purpose of no fault, right? It was to kind of slow down lawsuits and say we're only going to have lawsuits if there are serious injuries. And no fault was saying, when they came up with this concept, but don't worry, we'll take care of all your medical bills. Far from it. Anybody believe that insurance companies would actually put up a fight on all these claims? It's a fight on the no fault end, it's a fight on the liability end. But as much as they want, that was the initial concept behind no fault. All right, let's talk about property damage. This is relatively new. A year ago, if I was giving this lecture, I would tell you there's no such thing as a bicycle blue book or a blue book for bikes. Believe it or not, I was at Interbike, which is the largest bike show in the country in Vegas last week, and there's now a company called the Bicycle Blue Book. I don't know how they're doing it or how they're coming about evaluating an old bike versus a new bike. I don't know what they're doing to it. Really what I saw is a really good advertising platform for this company. So they set up this Bicycle Blue Book and then selling ad space on their webpage. But for the moment, I think carriers are going to catch on and start arguing that it's the go-to source for valuing a bike. My opinion is it's not. All right, it's a tangible item, just like a watch or a piece of clothing or anything else. And it's my argument to every carrier that you're entitled to replacement value, not depreciation value. And bikes change really rapidly. I mean, Trek, Specialized, every single year they're coming out with a new bike. And they're trying to keep up with each other and having the competition in the marketplace. So the bike that was available last year is not going to be available this year. So my argument is you're not entitled to be paid for the value of the bike, but you're entitled, if it cost me another $100 to get this year's model of my old bike because it's not available anymore, that's what I'm going to want. Vintage bikes are a little bit more difficult. There's a big movement to riding your people finding their parents' old Schwinn and fixing that up and taking that out for a ride, and they have value. I ride my mountain bike is a 20-year-old Peugeot mountain bike, and I bought it in for repairs, I guess, a year or so ago, and the guy's like, watch your back. He's like, Peugeot stopped making mountain bikes, this is value. And it's an old steel bike that I never thought was worth more than a couple $100, and apparently it has some value. So how do you value a vintage bike? eBay, Craigslist. You go to the marketplace and you see what are these bikes selling for? And you print those out and you send them off to the insurance carrier and say, look, this is a fair and reasonable value of a replacement bike. Another big issue, add-ons and modifications. Guys are taking their bikes, and girls, I shouldn't say just guys and girls, are modifying their bikes, or putting on seats, changing gearing, changing every piece of the bike and modifying the bike. That has value. So the bike might have been costing $1,000 out of the shop, and now a year later it's been modified and it's worth $2,500. Have your client keep copies of those receipts. Go to the bike store. Bike stores are a great source to get the value of a bike. One thing a bike store wants you to do is get money from an insurance company and come back to them and buy a new bike. So they're going to give you an evaluation of the bike. They're going to tell you what the parts cost, put it in a nice receipt for your client, send that off to the carrier. Also really important to remember to document the bike before you repair it. Take photographs, have your client take photographs. And I know we're spending a lot of time on this, but if you have a bike client, I guarantee you this is what they're going to be focused on in the beginning. Take whole pictures of the bike, not just a fractured front fork or wheel, but the entire bike itself. And then store the bike until the damage is paid. And we're going to talk about spoliation and what can happen to your client if they discard the bike or get rid of the bike before the litigation is commenced or during the litigation. All right, some crashes. Most common are doorings. Spend a good bit of time this morning talking about those. Right hooks, which is when a vehicle makes a right turn into or in front of the bike. Left hooks, side swipes, which are pretty obvious, and even hitting rears. I have clients that have stopped at a red light like a car, and cars driving to the back of them, or they're moving, and they get struck from behind, believe it or not. Or sometimes the multiple of these. And each one of these types of crashes have vehicle and traffic law that you can rely upon in improving your case. So left hooks are pretty obvious. And there's a little diagram of left hook. And usually occurs at an intersection. Clients going through the intersection with a green light. Car makes a sudden left turn in front of them. Really common cause of crash. Right hooks, also common. What's interesting, where right hooks tend to happen most often is actually at the start of a light, where cyclists in a car are parallel to each other, and either the bicyclist starts or the car drive starts, and the car makes a right turn into the cyclist because they're in their blind spot, or they don't look, turn their head, and they don't see them in the mirror. I think New York City this last week, I haven't seen it, started to do something called bicycle boxes. They were I know Portland, Oregon has them, and some other more progressive cycling cities have them. And what they are is actually literally a box at the top corner of the intersection. So the stop line for the cars will be about 10 feet back, and there's a box where all the bicyclists can wait together and start en masse, and it's much safer. One of you could argue theories about what's the safest way or to travel on bike. You could argue about safety of helmets, whether or not they prevent head injuries or not. The one thing that everybody will agree about is the biggest prevention of bicycle crashes is mass cyclists. A group riding 10 versus a group riding 1 is much safer. A driver is going to be much more comfortable riding closely to a single cyclist than a group of 10 people. They're going to be pissed off at the 10 people because they're not going to be following the rules of the road. They're going to be doing everything I do when I go to a bike club and tell them not to do, riding 3 abreast, having a conversation where the car's stuck behind them getting annoyed. It's not what they should be doing. They should be riding minimally single file. You can ride in New York 2 abreast as long as there's no cars behind you, but the group of 10 taking up the entire lane is an issue. But there is safety in numbers when it comes to bikes. And that's one of the reasons why New York City is getting safer, because there is no longer a single cyclist in a bike lane, but there's 10 cyclists in a bike lane. So the numbers definitely help. So that bike box is the concept to put the bicyclists together into mass, have them start together and make them more obvious for drivers. Okay. Blocked or obstructed bike lanes. And some of these photos I've actually grabbed from real cases. And this one is in the West Village, and this was a cyclist who was attempting to ride in the bike lane. I think it was Horatio, if I remember correctly. And the ambulance is there because it wasn't a successful ride. And you'll see what happened. But this cab stopped in the bike lane. All right? Right away, it's a violation of Section 4-08E of the New York City Administrative Code, which prohibits vehicles from stopping or standing in a bike lane. Even a cab for the discharge of passengers needs to be outside the bike lane. Right? Now, this creates a dangerous scenario. In this particular case, the cyclist left the bike lane because the cab was there. And to add insult to injury, after parking in this guy's bike lane, the cab driver then doored him as he tried to get him around him. All right? So we have two vehicle and traffic law violations here and 1 administrative code violation. But there are other scenarios that this can be dangerous, because if you force him out into a bike lane, let's say he gets hit by a passing car that's coming up behind him. There are other scenarios that can cause crashes, and you can predicate your claims on this section of Vehicle and Traffic Law 4-08E, which prohibits the stopping or standing in a bike lane. And this is the result of after him opening his door. The photos, I tell you, social media has become a great tool because, number one, New York City cyclists are a really cohesive group. They come to each other's aids, they come to each other's rescue. And this was a passerby who stopped with him and then felt free to take a bunch of pictures. So look, whether or not it's appropriate or not appropriate at the time, when I go to trial, this is a graphic photograph for me to show a jury, where he ended up in terms of the position on the roadway after the crash and the severity of the injury. So it sometimes seems morbid when people stop and take pictures. I don't suggest my clients taking pictures, but if a third party takes a picture and shares it with the client, it becomes great evidence, document or demonstrative evidence at trial. Why I'm there, social media. I didn't include this in the lecture. Tell your clients to stay off Facebook, Twitter, Instagram. It's amazing the number of people that think it's really funny to tweet or Facebook a photo from the back of the ambulance. But imagine a jury 2.5 years later. You're trying to sell this jury to a case how severe this injury is, and your client thought it was funny enough or not that severe at the time of the crash to put it up on Facebook. And Facebook is discoverable. New York courts have held that you need to turn over, if there's a reasonable reason to believe there's anything on there, your Facebook passwords. And forensic computer guys now and girls can get everything that's been deleted once they have the password. So you got to remind people to stay off Facebook and Instagram or wherever they're going to choose to post pictures. All right, so doorings. Anybody here not know what a dooring is? All right. Here's the definition of a door. The door zone is a space 2 to 4 feet adjacent to a parallel park or stop car. And by cycling the door zone, it can cause serious and severe injury if a door is either open into a cyclist or into the cyclist's path of travel. Now, doorings could cause injuries multiple ways. There are people who literally have the door open into their path of travel. Yep, please.
Is the cyclist supposed to avoid that zone?
So, it's a great question. And so the question is, are cyclists supposed to avoid that zone? So by concept, you're supposed to ride outside the door zone, which would be that 3 to 4 feet outside the door zone. It's not always possible, though. A lot of times, especially in New York City, if you have cars that are double parked, and now you're stuck riding to the left of that car or to the right of that car as it's double parked, and there's other vehicle traffic. You're kind of squeezing in between a very, very tight door zone. There's no legal requirement to ride outside the door zone. It's just good common practice.
Can a driver raise that as defense?
Absolutely, and we're going to talk, there's a lot of defenses to doorings. I don't think they're defensible, doesn't mean there aren't defenses raised. Yeah, and that's definitely one of them, the position of the cyclist, why they're riding adjacent to the car. You know, you got to remember also, when you ride a bike, especially in New York City, it's a hostile environment to ride. There's a lot going on around you, right? You have cabs, you have cars, you have pedestrians, you have construction, you have potholes. Your head is on a swivel while you're riding, and you should be on a swivel while you're riding around New York City. So to always maintain that perfect alignment of 3 to 4 feet outside the door zone is sometimes just not difficult. But it's definitely good practice, and it definitely could be a defense to a case. So, you know, having a door open into you, riding 15 miles an hour on a bike is like running into a brick wall. All right? And you are going to end up in one of two positions. You're going to end up either flying to the left or right into the car, literally over the door itself. And amazingly, the most common injury you see with doorings is going to be a fractured clavicle for multiple reasons, either striking the door itself, or what's very, very common in cyclist injury is after you leave the bike and land on the ground with your extended arms, pressure to your shoulders, your clavicle gives way because that's the most unsecured bone in your clavicle. And it ends up being a pretty serious injury. Number one is deformity. It's very, very difficult to have level shoulders after you fracture a clavicle. Going to spend some time at your tailor getting your suture refixed because you really have a big shoulder drop or a bump. Clavicle also, if you think of the anatomy, floats. It's one of the few bones that just kind of sits out there by itself with no muscle or structure underneath the clavicle. So once you fracture that, if it's any kind of significant fracture, you're going to end up having a plate put into that clavicle in order to close that fracture. So it becomes a really, really serious injury, a severe injury. In addition to that, a lot of times if a door is open into the cyclist, which happens quite common, causing the cyclist to lose control and lose their path of travel and traveling into car lanes, and they could be struck by a passing car. That happens all too often, unfortunately. And it's even a traumatic injury to the body. I have a client who had real fractured 2 fingers in his hand, as the badly fractured fingers in his hands, just from having his hands on the handlebar and the door being open into his hands. So you can have a number of injuries here. All right, so this is the law in the state of New York, which prohibits the opening and closing of vehicle doors. And no person shall open the door of a motor vehicle on the side available to moving traffic, and until it's reasonably safe to do so, and can be done without interfering with the movement of other traffic, nor shall a person leave a door open on the side of a vehicle traffic for a period longer of time that is necessary to load or unload passengers. All right, so let's talk about 2 things we need to know in the statute. Number 1, traffic. For the purposes of the vehicle and traffic law, a bicycle is considered a vehicle. All right, so it's applicable to this section. The other thing that I like about this, and we'll talk about defenses, is, we'll get there, but about leaving the car door open for more time that's reasonably necessary to enter or exit the vehicle. Now, in addition to the vehicle and traffic law in New York State, there's also an administrative code that prohibits the opening of a car door. And that's section 4-12C. So in the city of New York, in addition to the vehicle and traffic law, which some are applicable within the city of New York and some are not, there's a section of the vehicle and traffic law, I believe it's 1212, which eliminates certain parts of the vehicle and traffic law of the state of New York within the confines of the city of New York under the home rule. And what gets added in some circumstances are the administrative code of the city of New York, which is its own rules and regulations. Now, there's a difference between a statute and an administrative code for the purposes of negligence. And going back to law school days, violation of a statute of the vehicle and traffic law is negligence as a matter of law, right? Violation of an ordinance or an administrative code is evidence of some negligence. So in terms of purposes for either a directed verdict or trial or for summary judgment, an administrative code won't get you there, where a VTL has a much better chance of getting you there. But here we have the advantage of both. So when I go into my charge conference with the judge and they ask me what sections you want me to charge a jury, I'm going to ask for both the VTL section, which I read earlier, and the administrative code. So the administrative code is no person shall get out of a vehicle from the side facing on the traveled part of the street in such a manner as to interfere with the right of the operator of an approaching vehicle or bicycle. So even better in this particular statute, they mention bicycle, right? And what I like better in this statute than the VTL is approaching. If you go back to the second statute, it doesn't talk about anywhere about approaching. It just says to interfere with moving traffic. When I sum up to a jury and the driver says, I looked and I didn't see anything. Well, the bicycle didn't come out of nowhere. The bicycle was approaching this car. So if you could tie your testimony of the defendant into the statute, it marries very, very nicely. And it also specifically referenced bicycle. Now, a lot of cases are going to be involving New York City cabs and doorings in New York City cabs because people just don't look. They're playing with their cell phones, they're playing with their BlackBerries. You have a lot of tourists that are utilizing cabs and they're getting out of cabs on the travel side of the roadway or even on the safe side of the roadway, but still not looking. So if you have a case against a New York City cab, you can add on to the statutes again, New York City Administrative Code 4-11, which requires taxis to pick up and discharge passengers, must be within 12 inches of the curb or parallel thereto. So if you have a cab who's now parked outside of maybe a car length or 2 car lengths away, and your cyclist thinks he's either a stopped car waiting at a light and believes he has a clear path to travel down the right side, passenger gets out on the right-hand side, we now have a violation of this section of the Administrative Code because he should have been over by the curb or at least parallel there too. Okay, so now,
Quick question.
yeah, please.
In that case, do you sue both the cab
Great,
and the passenger?
great question. So the question is, in that particular case, do you sue both the cab and the passenger? And the answer to that is yes and yes. The problem is, a lot of times the passenger is not identified. Passenger, sees what happens, says, oh shit, and runs, right? And now the cab driver's sitting there, trying to find this guy or girl, and the cab stays at the scene, and all we know is the cab driver and the cab owner and the insurance company for the cab. Some people stick around, all right? And I've had circumstances where I've collected only naming the cab and the cab driver. I had a circumstance relatively recently, last year, where the person didn't stick around, but we got there, they didn't give any information, but they paid with a credit card. And the cab company was smart enough to say, hey, we're impleading this person, and you should probably do the same thing. And it turned out in that circumstance, there was a woman who lived up in Westchester, had a homeowner's policy that covered her under this loss. And rather than the cab paying the bulk of that claim, her insurance company, the exiting passenger's insurance company, actually ended up paying the bulk of that claim. So if you can get jurisdiction over them, yes. Another issue, if it's a smart defense lawyer, is going to ask for an Article 16 set-off. So when they go to trial, if you didn't name that driver or that exiting passenger, they will try to assert, and probably it depends upon the judge, they shouldn't, because technically, I'm getting a little technical, but auto case is joint and several liability, so you really shouldn't have any kind of set-off. But they surely might try to argue to the jury outside of that, well, it's not our fault, it was the passenger's fault, and try to argue an empty chair defense. So if you can get them, I think it makes more sense to name them. If they default, then you've done what you can do, but I think it makes more sense. Now, the bigger issue, though, ultimately is insurance, because it's wonderful to be able to name somebody and sue them, but if we can't be able to collect at the end of the day, that creates a bigger issue. So there's a couple of Court of Appeals decisions that talk about passengers, and that the insurance company is required to provide coverage for the exiting passenger under 388 of the Vehicle and Traffic Law for use in operation of a motor vehicle. So that's really the bigger issue, because you could sue them and then, great, you get a judgment and hang that on the wall for the next 20 years. So the answer is yes and yes, you do both. All right, so now to your earlier question, common defenses that you're going to see. My door was open for over a minute and your client just rode right into it, right? Which is really common. When I first started doing these cases, this became a real common defense. I guess every single defense lawyer said, oh, this is going to be the answer, because my client had nothing better to do that day than ride into an open car door, right? So, but go back to the statute we looked at earlier, which was the VTL. And this is why this is really important, because that doesn't get them out from under the statute. Because you can't leave your car door open for over a minute too if you're not getting in and out of the car. Because the vehicle and traffic law says, nor shall any person leave a door open on a side of vehicle traffic available to moving traffic for a period of time longer than necessary to load or unload passengers. So I don't really believe that to be a viable defense, because you can't just leave your car door open into moving traffic. So if I was defending a dooring case, or I'm preparing my client to testify for trial or deposition, the things that I focus on are what we talked about, the position. Well, let me start from the beginning. Is there any sign to the cyclist that a driver or passenger was about to open a car door? For instance, did an interior light of a car come on at night? Can the driver see into the car and see if the people are sitting? There's a presumption if somebody pulls into a parking spot, the next step is going to be they're going to exit. So did the cyclist see somebody sitting in the driver's seat or passenger seat? Interior lights. Brake lights. One of the first questions I asked drivers, was the car running or shut off? Because if there's a brake light on in the car, well, then the cyclist at least knows there's somebody in the car, and it creates some other awareness that a door may open. Position of the roadway. Going to your question, could they ride clear of the open doors, or is there anything obstructing their path of travel, either onto the left or the right, or they were kind of boxed in? You think of a bike riding up, back up a second, there's nothing to prohibit a cyclist from riding in between cars in New York City, okay? In New York State, if the road is more than 40 feet wide, you need to ride on the right side of the road. The city streets, you can ride either left or right side, because these are not more than 40 feet. And unless it's a designated bike lane, you need to use the designated bike lane. Okay? But if you have cars that are stopped, let's use Fifth Avenue, cars are stopped on the right-hand side of the traffic light. There's a parking lane to the right. Cyclists can travel up that middle. There's nothing to prohibit that. It's perfectly legal, and nothing to get a citation about. But it creates a pretty narrow path with no place to escape, because you have cars to your left and cars to your right. So that's one of the things we look at. Was there any way to avoid the door? At night, was your client using bike lights, reflectors? Speed and braking ability is really important. And ultimately, where was the client looking at the time of the crash? Were they looking straight ahead? Were they looking to the left? Were they looking at their phone? They all become issues. This one was a new one for me about 3 weeks ago. Although I heard of them and I know about them, I never had a client riding one. Anybody know what fixies are? Okay, so fixed gear bikes, it's a trendy, fun bike to ride, and it's what you see as a racing track bike where you don't have any brakes. All right, the bike is a fixed gear, and the only way you control speed is by pedaling or by trying to slow your bike with your leg speed. Fixies are an ego thing. People who ride fixies will tell you they can brake and stop a bike better than anybody with a brake, but they're illegal. And the vehicle and traffic law in the state of New York has certain requirements for bikes, equipment. In VTL 1236, it's lamps and other equipment, headlights and taillights from dusk to dawn, bell. I think it's the silliest statute in the world, because you need a bell or other audible signal, because a bell is going to save me from a Mack truck, right? And ultimately, working brakes. So fixies technically don't have working brakes. What you see people do in order to get around that statute is literally just put a non-functioning handbrake on the bike so that the cops don't stop them, but they still don't have one. So you might want to ask your client and just go over whether or not they're riding a fixie at the time. All right. Preservation of evidence. I was talking earlier about the bike and photographing the bike and things that you want to make sure you keep preserved up until the time of trial. If your client can, put the bike away in a safe place. It's not so easy here in a studio apartment to tell your client to hold on to a crashed bike if they don't have a storage unit, but if you can, I would say hold on to it. Bike helmets, gloves, and other damaged equipment, tell your client to hold on to that as well. Once you start the lawsuit, if you're under pressure to get rid of the bike, I would serve a notice of availability to your adversary saying that the bike is ready and available to be inspected. If you want to inspect it, we'll make it available to you at a reasonable place and time. I've yet to have anybody ever ask for it. They ask for it later on, sometimes at a deposition. I very rarely think that the bike is going to be, well, I shouldn't say that. I'll give you an example of a case shortly where the damage to the bike can be critical in terms of point of impacts and things like that. And I also photograph it as well. I have the client photograph it because if they argue the bike was destroyed, we're like, well, judge, we have photographs, and their expert could look at photographs. There's no reason to physically look at the bike. It just creates another level of protection for you. But here's a case from the first department this year, actually. And this was a case involving a dooring. The dooring occurred in July of 2010. Some 2 years later, the defendants demanded the bike. At that point, plaintiff lived in Manhattan, didn't have room to store the bike, and it had been disposed. Nobody asked for it before. They moved for spoliation. So spoliation is a remedy fashioned by the court that can either strike an answer. So if a plaintiff doesn't preserve some piece of evidence that the defendants would need or have to show they need to prosecute the case, or if a defendant gets rid of evidence that the plaintiff needs to prosecute a case, the court can fashion certain remedies. It could be dismissing the complaint in its entirety. That's the most severe sanction. For a defendant, it can be striking their answer as the most severe sanction, or it can be somewhere in between where what they would do is say, we're going to, at the time of trial, this jury is going to be instructed what we call a spoliation charge. And there's a section of the pattern jury instruction for spoliation that either a plaintiff or defendant, whoever's seeking the charge, that jury is allowed to assume that that evidence would go against the weight of their case. So if it's my case and got rid of the bike, and the judge said, I'm not going to dismiss your case, but at the time of trial, we're going to allow the spoliation charge, and jury is allowed to consider that evidence would have bolstered my case and the defendant needed it in order to defend the case, and you're allowed to assume that that evidence was not favorable to me at the time of trial. That's a less severe remedy that the courts will use. But in this case, lower court denied the motion, went to the appellate division, and the first department denied it, saying there was no evidence that the bike was disposed of in bad faith or any evidence or testimony that it was necessary to prosecute or defend the case. But who wants to be in this position, right? Because now you have a plaintiff who's survived in the lower court, having their case dismissed, and then had to worry about going to the appellate division and deal with an appeal, which all would have been avoided if they just held on to the bike. All right, electronic evidence. This is a fun one. You know, anybody read the New York Post this morning? Cover the New York Post? No? All right. You're all up too early being here at 8 o'clock in the morning. All right. So we all know about the unfortunate incident that happened in Central Park on Thursday, where the woman was struck by a cyclist. It's a horrible story. She was in Central Park Thursday afternoon, walking in the park when she was struck by a cyclist, a competitive cyclist who, and she suffered a real traumatic brain injury and is still in it's a horrible story. And the wife of an executive at CBS, so it became even more sensationalized. So the story was first reported on the cover of Post. Today is Saturday, I guess on Friday. It was on the cover of the Post because the Post likes to sensationalize things. And what was interesting today was still on the cover of the Post, which amazed me. But they talked about Strava today. And Strava is a program that you use. It's used either by an iPhone app or like I have a Garmin on my bike that can link with Strava. And Strava collects all your data as you ride. So you use it to train. So it shows you your path, your speed, elevation, cadence, all critical information you want to collect while you ride. And today in the Post was all this guy's Strava information, which is very interesting because the Post went and got it. It's out there. A lot of people use it. Strava links with Facebook. So people will finish up a ride and post their Strava and say, oh, I did a 50-mile ride and I had a PR of X. So he was using Strava, I think at the time of the crash, or if not the day before, and was boasting about his PRs, his rides that he had done in the last couple of weeks, and the fact that he had rode earlier that morning in Central Park and had finished a loop at 30 plus miles an hour, whatever the information was. So Strava's, it becomes an issue, and that's the first time I ever saw it mentioned in a paper. But that's what Strava is. And it can also be used to help you, though. If there's an issue with regard to your client's route of travel, we now have a documented route via GPS from the time your client left their location up until the time that the crash occurred. Like any electronic data, the trick becomes admissibility, right? So I can collect everything under the sun and try to put it into evidence at time of trial, but there's a gatekeeper, the person in the black robe on the bench, and it's going to say, that's not coming in because how do I know that's authentic? So with Strava, you got to be real careful about chain of custody, and walk your client through the process in which they downloaded the data. What did they download? What did they download it onto? Did they burn it onto a CD? Did they They put it onto a drive and provide it with you, because you're going to need to establish chain of custody like any other piece of evidence. And once you have that data, make a copy and keep it safe, because you don't want to end up with a spoliation defense, right? Here's a perfect example. Client goes to their deposition, and a smart defense attorney, and a lot of people don't know about Strava, so you're not going to expect every defense attorney to ask about it, but to say, oh, were you using any type of electronic device? Yes, I was using Strava. Great, where's the data? I deleted it. Well, guess the next stop for that lawyer is going to be at the judge asking to have your case dismissed because you just destroyed evidence. All right? So all these things, as much as you collect all this data or evidence or proof, you got to make sure you're keeping it safe, because 2.5 years later you're going to be in front of a judge and jury and you need to present it. How about GoPros? You'll know about GoPros. Yes, some, okay. So GoPros are awesome. And a GoPro is actually just went public. Google bought them for a couple $2 billion. And it was a bunch of guys out in LA who came up with an idea for a waterproof camera when they surfed. And that was the original idea about GoPro. And everybody said, why are we just using this for surfing? People are using it for skiing. They're keeping it mounted on their bikes. And it's recording data onto a little tiny camera from the moment they get onto their bike up until the time the crash occurs. Now, GoPro can be the best thing or worst thing, right? Because a photograph or a video tells the truth. So whether it hurts you or helps you, you have this evidence is out there. So I don't have a video, but I was able to grab a couple of stills for you off this. And this is a cyclist who's riding. This is his view in the bike lane. I think it's on 5th Avenue in Brooklyn, if I remember correctly. I don't know if it's too clear or not. You're going to see he's approaching this intersection, and on the left-hand side, if we can get there. So that's the car approaching underneath the arrow. And we can't see too well. I don't know if you can see it up here. It's kind of covered by the arrow. But we have, in the picture, we have the green light. And on the video, we have him going at a reasonable rate of speed on the video, approaching the intersection. As he gets into the intersection, all of a sudden, this car makes a left turn. I don't see a directional illuminated in that picture, and you won't see one on the video as well. And we have a crash ultimately occurring right in his bike lane, which took on video maybe about 1.5 seconds from the time he entered into the intersection until the time that the crash occurs. And ultimately, the camera's mounted on his bike. That's not him. But he did sustain a real severe shoulder injury. He fractured his clavicle, had to have surgery, and a separated shoulder. Pretty bad crash. But I couldn't ask for better evidence than this. And believe it, it's funny. What I did, and I'm not surprised, but one takeaway from this lecture today is, as much as I have respect for the bench, don't always believe that just because they're wearing the black robe, they're the smartest ones in the room. But I moved for summary judgment on this case, pre-depositions, because I was like, well, what else do I need? I have a video, I have a client's affidavit stating the authenticity of the video, the manner in which he recorded it, what he used to record it, how he provided it to me. We gave a copy of the video to the court, and I argued before the judge last week, and she said, well, they're allowed to ask him questions about the video before I grant you summary judgment. So she denied my motion with leave to renew, and then I'll be back there hopefully in 3 months with a copy of the video, and if I lose there, then I'm going to the appellate division. But you can't ask for better evidence than GoPros. Now, at the same time, if there's a GoPro that shows your client doing something stupid, it cuts both ways, right? So be careful what you ask for. But it's a fantastic video, and I've had multiple clients call me and say they have crashes recorded on GoPro, which is really good. And I had a guy, cameras are everywhere, right? So I had a client not too long ago, he was a dentist in Brooklyn riding his bike to work and had a crash at an intersection, pretty gruesome when you look at it on the video, but knock on wood, he was okay. But he went to an adjoining property building and he saw the camera up there. And he went to the landlord or to the owner of the building and said, do you have that video? Sure enough, she pulled the video for him and gave him a copy of the video, and it shows the car running the red light right through the crash. So, first of all, don't believe the 30-day rule. It used to be the old rules that everything gets rewritten over 30 days. Servers are much larger now than they were a couple of years ago. I think the video is getting preserved a lot longer. That always became like the go-to answer, oh, we delete it after 30 days. It's probably still there. But send an investigator out, take a look around a sidewalk, take a walk up and down the streets, look for cameras, see if the person's willing to provide it. If not, send a letter to the property owner, just asking them to preserve it at least. Sometimes you can get a court order to get it, sometimes not. But these crashes are happening outside, right? So there's going to be a video camera, probably on a building somewhere. You're not going to get New York City NYPD surveillance camera unless they pull it for you themselves. You won't get it if it's a death case. CIS will pull it, and you can get it that way through FOIL. But private cameras, I got one from the Department of Education recently, from the school security. They gave it to me. So take a look for them. They're really great evidence if you can get it. All right, so that's cameras. Anybody have any questions about cameras while I grab some water? Yes.
In that case, if granted that the video was submitted, the summary judgment motion would be based upon the statutory requirement to use a signal, and that would be not.
Yeah, it's going to be, that case I argued, I think, if I remember correctly, 4 vehicle and statute violations. So I argued, if we go back to the picture, illegal left turn, right? So right away that the driver of a motor vehicle in New York State is required. Let me repeat the question first. The question is, what did I rely upon? I'm moving for summary judgment. Was it the video alone or statutes? And I relied on 4 statutes. One was the basic statute of the vehicle traffic law, which I can't cite off the top of my head, but that's the requirement of a vehicle to give way to an approaching vehicle prior to making a left turn in front of that vehicle. So that's one. Number 2 is failure to utilize a signal. Okay. Number 3 was entering a bike lane when a bicyclist was there. And if I believe the 4th was a section of the administrative code, I think also with regard to signaling, because the New York City Administrative Code has its own law regarding left turns in addition to the vehicle and traffic law. So 4 separate statutes in addition to the video. That's why I'm not so happy I lost. But not surprised, and I'll be back to re-argue it again. Okay. All right, Whitdorf versus City of New York. This is a Court of Appeals case that came down this year, which is really, really important, not just for cyclists, but dealing with immunity from the City of New York, or from municipalities, not just the City of New York. This one dealt with municipalities alone. So at its barest, a municipality, when it undertakes an act, is provided with certain governmental immunities when it's a discretionary act. So let's use the simplest form of a discretionary act would be a traffic agent standing at the Midtown Tunnel directing traffic, and he or she negligently waves on 2 cars at the same time and they crash, right? Well, in your mind, you would say, wow, that's a great case against the DOT because that traffic agent messed up in directing traffic and caused this crash, right? Not so. When a municipal agent undertakes certain actions that are discretionary, they are entitled to qualified immunity under the law. And that's also police officers. This goes to the whole line of cases, whether or not a police officer acted reasonably under circumstances, protecting somebody, responding to a call timely. All these type of things that create governmental immunity. And for years, the municipalities hid under this. Administration for Child Services, Department of Education. Anybody that was doing a discretionary act would hide under this immunity. And Whitdorf actually dealt with bicycles and kind of blew that all up for these municipalities. So the story behind Whitdorf, she was riding in Central Park at the 65th Street Traverse. And it was early in the morning, and she and her boyfriend, I believe at the time, had encountered a DOT crew setting up to do a pothole repair. And they asked the supervisor who was setting up, is it okay to ride through the Traverse? And he said, sure, go ahead. So the boyfriend rides through with no issue. And Ms. Whitdorf, she's right behind him. She rides through, she hits a pothole, and she crashes. So Ms. Whitdorf sues the City of New York and the DOT on a theory that that supervisor was negligent in allowing the plaintiff to enter the Traverse. And the jury agreed with her. and they found the city to be 60% responsible for the crash, and Ms. Woodhorf 40% responsible for the crash, being comparatively negligent, right? So New York State is a comparative negligence state, so a jury is allowed to consider, as you all know, each party's culpable conduct in causing a crash. So here they said the city's 60% responsible, but Ms. Woodhorf, whatever you did that day, either not looking properly, I don't know what the jury based it on, they found her 40% responsible for the crash. City, at the end of the case, moved to set aside the verdict, which was granted by the trial court. That same judge who heard the case and heard the jury's findings said, you know what, I'm throwing it out, and I think the city of New York is entitled to governmental immunity under this discretionary function theory. And it went to the appellate division in the first department, and the appellate division agreed with the lower court, who also found that the supervisor's act of waving her through the park was a discretionary function and not a proprietary function in causing the crash. So they go up to the Court of Appeals. Now, here's the best way to describe the difference between a discretionary act and a proprietary act, all right? And this case was very, very clear. In this circumstance, the Court of Appeals found that that supervisor was acting as the same role as a private contractor. So if it had been subbed out to any person that does work in the city of New York, and that private contractor versus a DOT employee waved them through, that private contractor would be responsible. But that same DOT employee who was doing the same job up until this case was immune. And the appellate division said that's not accurate and it's not fair. If a governmental entity is undertaking the same role as a private contractor or stands in the shoes as a private contractor, they should be held to the same standard of negligence. And they actually reinstated the verdict, and I think they set it down for a new trial. I'm not 100% sure what ended up happening. The Court of Appeals decision wasn't really clear if it went back to a new trial or they reinstated the verdict. But this opens up a whole new theory, not just on bicycle crashes and premise cases, and we'll talk in a moment about road defects and things like that. But even any other case where an entity, a municipal entity, would be seeking governmental immunity under the theory, and now opens up police claims, ACS claims, school claims, all those things are a lot broader now because of this decision. Okay. All right. Let's talk about traffic calming devices. So traffic calming devices is a term of art that's used to devices that are installed in New York City streets to control traffic. So a great example is now that Times Square is closed off to pedestrian traffic, that's a traffic calming device. You'll see a lot now outside in Brooklyn and Queens and residential neighborhoods, the installation of rotundas to slow traffic. Those are traffic calming devices. And speed humps or speed bumps, and they're used interchangeably. Speed bump is usually something sharper with a higher angle of attack, whereas speed hump is what you usually see in a roadway that's going to have passing traffic, which is a little bit more calmer and easy to navigate. But they're also put into bike lanes. And when put into bike lanes, there are certain things that need to be taken into account. And those are, number one, when you install a speed bump or traffic calming device, who's using the roadway? You know, something that is usually safe for a car is not going to be safe for a cyclist. Something that causes your coffee to spill inside a car can cause a fracture or serious injury. So as the city is starting to adapt to realize that more cyclists are on the road, the concept of mixed use has to be considered when you're installing these type of devices. So in this photograph, this is actually outside Pratt in Brooklyn. And it's an interesting story, and we'll use this as an example of what records we're looking for when we take on a case against a municipality involving a defect. But in that photograph, nobody sees a speed bump, right? Well, even at the arrow. And the speed bump is there. It's under the shadows of the trees. So if you're an approaching cyclist riding on this bike path outside Pratt on a nice spring morning day like this young man was doing, you're not going to see that speed bump until you're right on top of it or are in the process of going over it. Now, what should be there? Well, after the crash, DOT said, uh-oh, and they came out and they put the bump there. And those are the things that you're looking for about proper markings, and also chevrons, which are these little signs over the top of the speed bump to let people know that they exist and that the speed bump is there. So we go back and not visible at all, little more visible as he approaches it, but obviously, some 100 feet back, there's a bump on the road letting him know it exists. Another issue in this case, I don't think the speed bump belongs all the way across to the bike lane. It should have ended at the bike lane, but in this case it doesn't. It goes all the way across, but at least we have the chevron here. The other thing we're looking at is signage. The DOT has its own rules and regulations. Believe it or not, there is a speed hump department or speed dump department at the DOT. All right? And there's a whole process about going about getting a speed bump placed in a neighborhood or in front of a school. And here was a request by Pratt to have it. But there's a requirement also, in addition to road markings, for proper signage. So one of the things you're going to be looking for, where were there signs, were there proper signs, who put them up, and where were they placed? So that's this particular case in front of Pratt. So I'll give you a little background about this particular case. Pratt wanted a speed bump on the street. The process normally is submit a request to DOT. DOT comes out and does a field study, and they'll have a community board meeting, and they will investigate and take a look at traffic patterns in or about the area and decide whether or not to approve or disapprove a speed bump. And that's any neighborhood in New York City. This is normally the process. Community board will go and ask for one, and it'll be based upon certain criteria, whether or not it will be allowed. When you get involved in any case involving any design on a New York City street, or actually I should say any street in the state, there are certain guidelines that exist. There's a New York City master plan, and all this stuff is available online on the DOT's website, or just simply Google it. And the New York City master plan is kind of a design guideline for the city of New York, which is a combination of all the national guidelines for design and maintenance of multi-path and mixed-use roadways. And so the definition of that is shared by pedestrians, cars, and bikes. And it talks about standards throughout the country that are utilized into making the street safe and usable for multiple use. And then going back to the traffic speed bump, there's actually a New York City traffic calming device guideline as well. And that talks about where they should be placed, how they should be placed, and the manner in which they should be marked, and when and where they should be used, which is also really important. They have their own guidelines for the installation of speed bumps, speed reducers, signage. Another type of traffic calming device is lane narrowing. So we take lanes from 2 lanes to 3 lanes. I'm sorry, from 3 lanes to 2 lanes, or 2 lanes to 1 lane, slowing down traffic. Sharrows. No, there you go. Got a couple of raised eyebrows on a sharrow. Sharrows are those things you see at the end of a bike lane. So I'll use the Midtown Tunnel example. So 2nd Avenue has a bike lane that runs pretty much the length of the length of it. When you get to the Midtown Tunnel, because those cars are making lefts, it becomes a sharrow. And sharrows looks like little, they become little triangles versus a marked bike lane. And it's for a shared bike and car lane because cars have to make a left to get into the Midtown Tunnel. So those are called sharrows. You see them all over the city. They're almost all, they paint them and they get ripped up pretty quickly because cars are going over them. So they kind of fade relatively quickly, but that's a sharrow. And then there's the American Association of State Highway and Transportation Officials, the AASHTO, which is a huge guideline that sets forth the standards and test protocols for highway design and construction throughout the United States. It's the gold standard for street design in the state, in the country. And actually, I think it was their last meeting, they finally, for the first time and since its existence, have actually started to recognize and delineate bike lanes within their categories and within their standards. So it's the first time it's being recognized. It's a lot more solid and usable in a bike crash case with a claim against a negligent street design. So when you're arguing a case against a municipality with regard to road design, you have to remember mixed use. And going back to what I was talking about earlier, something that's safe for a car or for a pedestrian may not be safe for a cyclist. cyclists are doing things that are different to a car, right? You have to maintain anywhere from 5 to 8 miles an hour to remain upright, right? So anything less, you're going to fall over. So you know a bike is moving faster than a pedestrian. So what's safe for a pedestrian might not be safe for a bike. Things that are safe for a car to travel over on 4 wheels is not going to be as safe for a cyclist traveling over that same debris or device. Cyclists have different levels of experience. There are some cyclists who can hop their bike up the side of a mountain sideways. They're not going to fall over a speed bump. They're going to be able to handle it. My 75-year-old mom, I'm not going to put her over a speed bump too quickly on her bike. You know, every cyclist has their ability to handle different defects, but when you're designing a street that's for mixed use and for mixed users, all those considerations have to be taken into effect. This also goes with regard to construction areas and lane designs, and I'm going to get to that a little bit as well. But you know, who's using the road at what time and what periods of time? You know, there's higher bike traffic on Kent Avenue in Brooklyn, for example, during commuting times than there might be midday. It's a real high traffic route. You know, what do they consider during construction in terms of closing the roads? Signage is really, really important. Also, anytime you're going to deviate a cyclist path to travel, we all see during construction in the city, you see bike lane closed, the signs up. You know, you need to have signs up warning people about approaching construction. So I'm going to give an example of a mixed failure to consider mixed use. This is over by the 34th Street heliport. Some of you may be familiar with that. And this is a shared pathway. And my presumption is this speed bump was placed there for the purposes of slowing traffic coming off the FDR, going into the parking lot that's behind the heliport where there's parking for Langone Medical Center. And because there must have been pedestrians crossing behind that building and being blocked at the far end of the picture, they put a speed bump there to control or slow down car traffic. The speed bump, if you look at it, doesn't look very dangerous to a car. And I don't have a better photo, but I can describe it for you. That speed bump is about 2.5 inches high, relatively short in terms of its dimension across the top. And what's also more troubling about this speed bump is that there's no markings anywhere about the approach of it, that it's going to be on the roadway, and that there's a speed bump ahead. There's no markings on the ground. And what's also not taken away from this picture is at the end of this intersection is 34th Street. It's a very, very busy intersection. Also, at the end of the building is the East River, opens up onto the East River. So sunlight now is coming into you as you're riding on this path, so making this less visible because the rider now has sun glare in their eyes as well. And this might be a very appropriate speed bump for a car, but it caused a very serious injury to a cyclist. So there are certain speed bumps that are supposed to be used for mixed paths. So this is actually the development that is, God, I don't know, maybe a quarter mile to the south, Rivergate. And this is a great example. If we just walked down, or if the guys at the 34th Street heliport took a walk down the road and saw how to put a proper speed bump in. You have an obvious speed bump. It's painted bright yellow. The angle of attack of that speed bump is much less, making it much safer for a cyclist to pedal over. You have warning signs, multiple warning signs about its existence. So these are the things that you're looking at when it comes to speed bumps. All right. So let's talk a little bit about records. Anybody have any questions about speed bumps? Okay. All right, so when I start to investigate any case involving a municipality, the city of New York, or a road design case, the first thing I do is file a FOIL request. And there's certain things I'm going to be looking for. 311 complaints are a great way to start, especially if you're trying to prove prior written notice of a condition. So a prerequisite to bringing a case against the city of New York or against any municipality, number one is filing a notice of claim. So if you have a road design case against the city of New York, the first thing you want to do is file a notice of claim within 90 days of the occurrence. One of your burdens in proving a defect, like a pothole or some other condition on a road that isn't affirmatively created by the city. So separate and apart from that example I gave you at Pratt, where somebody affirmatively created a dangerous condition at the city by installing that speed bump, separate and apart from that, you're going to need to prove prior written notice of that condition. So how do we do that? It's either by somebody literally filing a complaint, writing a letter to DOT, or it very well may be a 311 complaint. 311 complaints are good if there's corrective action that's taken after them. The phone call to the City of New York alone isn't going to be enough for prior written notice, but when I get the printout of that 311 call, it's going to say action taken or no action taken. And it's going to say reported to the DOT, the time, and who they reported to. So now I need to know, now I know early on in this case that I'm going to go to the DOT and ask them for those records specifically related to that complaint. Corrective action reports. Those are created by the DOT as to what they did after the report was given of the defect. Contracts, that has a lot to do with private defendants who are contracting with the City of New York in terms of opening up roads and things like that. I'm going to look for prior notices of claim for that condition. So as I mentioned before, filing a notice of claim is a prerequisite to bringing a lawsuit against the municipality. I want to search and see if there are any other prior notices of claims ever filed about that condition before my crash. Fitch reports are kind of like a construction report created by DOT, and Big Apple maps. Big Apple maps it was a very old concept. They still exist. So before the change in the administrative code, making adjoining property owners responsible for the condition of sidewalks in the City of New York. So right now, like this particular building, for instance, if you fell outside on the sidewalk in front of this building, because it's a commercial property, the duty to maintain that sidewalk has now shifted from the City of New York to commercial property owners. But before that, there was a company called the Big Apple Pothole Corporation. And it was funded by New York State trial lawyers who supported it. And really what this was a bunch of people who ran around the City of New York looking for defects in sidewalks and in crosswalks. And they would take a map and make a legend or a mark on a map, and there's a legend that said raised sidewalk, pothole, and they would send it to the DOT, certified mail, return receipt requested, reporting the condition. So the first thing I do if I have a client that came in and said I fell on a sidewalk or I fell in a crosswalk is I send a letter to the DOT and I give them the location, and they make a search. And you send them 2 checks. I think you send them, if I remember correctly, one was like $250 and one was $150. And if they made the search and they found the map, they kept the $250. If they made the search and didn't find the map, they sent you back $150. And the Big Apple maps were a great way to prove prior written notice, were the only way to prove prior written notice of a condition because a letter is being sent to the DOT. And then you get to meeting with the corporation counsel to come up for trial, and you argue over whether or not that little dot on the map is what we're talking about or not. But at least it gets you to that level. It gets you past the gate. But you could still use Big Apple maps because if you could find an old one that reported a road condition that might have existed 10 years prior, it's great notice to the city as well. All right, so anything that's done within the City of New York almost always requires a study to be done. So that Pratt example I gave you with that speed bump, I know now after looking at the records I had there that there was a complete study done by the DOT prior to the installation of that speed bump. There was a plan done to draft out where the speed bump was going to go. There was place for signage, although it wasn't there. There was a place for markings on the street. They do street criteria studies, and or street hardware studies. And we all know you see vaults and manhole covers and all those things. Well, those are all considered when they're doing any type of infrastructure into the City of New York. Those are studied. Community boards are great. We all know community boards are the first to complain about a bad condition and then the first to contact DOT if there's something bad in a neighborhood. So it's a great place to go to the community board and see whether or not they ever complained about a road condition or defect. Highway Quality and Correction Assurance. This is an agency of DOT that inspects construction, I believe, after it's done. And all these things can be done via FOIL. And there's some really good case law, because a big argument you have with the City of New York is they want me to give me, when I go to a preliminary conference, one of the things they demand from me is a copy of my FOIL response. So they're asking me to give me the records that they were supposed to give me but didn't give me, and I got them on my own. So you can do both. You can do a FOIL request and also prevail yourself of the regular discovery process with the City of New York or municipality. request the records directly, in a notice to produce or a notice for D&I, your preliminary conference, and stay diligent about it. There are records that I get under FOIL because there's no at Corporation Counsel, somebody's filtering what I get. There's an attorney who's drafting the discovery response. FOIL is a FOIL unit that should turn over everything, and a lot of times the records I get from FOIL are a lot better than the records I get from discovery. And I FOIL twice because I have two different people. You very often have two different people doing the FOIL response, and one might be as lazy. The other one might be a little bit more diligent and make a better search. So I tend to FOIL two different times during the course of litigation. It's relatively cheap to get the records. And this is another great one. Don't forget email. I was talking to a gentleman who just retired from the New York City Department of Transportation who testified a great deal on road design cases on behalf of the state of New York. And he was amazed how many people never asked him about email. They would ask about studies and criterias and plans and everything else. He's like, we have all that stuff, but most of our conversations were via email. And if you don't specifically ask for email, you're missing out on a great opportunity. And I'm going to use that Pratt example again. So the reason I haven't deposed anybody from the city of New York yet on that case, the reason I know that there was a 3.5-week delay from the installation of that speed bump up until the time that it was painted is because I have an email. And the email is from one person at the DOT saying, let me know when you finish installing those speed bumps at Pratt. And the other guy wrote back saying, we did it 3.5 weeks ago. He's like, oh, let me know next time you do it because we're supposed to be notified so we can go out there and paint them. I didn't find that in a contract. I didn't find that in a study plan. I found that in an email between two agents of the DOT. And that's my whole case now because their own criteria is to be painted within a week of installation. And I have an email saying, hey, you never told me 3 weeks later, and now they got out there about almost 4 weeks after they painted it. So email is really important. So as is important, what you're looking for are the things that are supposed to be present. So nobody can put a shovel into a city street, probably any municipal street, without having a permit, right? And every permit is going to have certain stipulations attached to it. So if Con Ed or any other of the contractors you see throughout the city of New York, especially like on a Saturday when they're cutting up the city streets, they're going to have to apply to DOT for a permit. And on that permit is going to be conditions. And the conditions are going to be everything from when they can close the street, how long they can work, and especially with bike lanes, and it's a relatively new stipulation they've added, there needs to be proper signage for the closure of a bike lane. There needs to be construction signs, both before and after the bike lane closure. I'm going to show you some examples of flagmen. So if there's going to be lane closure, usually stipulations require that the construction company has literally somebody with a flag slowing traffic or controlling traffic. More importantly, there needs to be proper and complete restoration of the street after the construction is done. So a lot of times you'll have a temporary closure. They do cut up a city street, do the work they need to do underneath, whatever it's a pipe or whatever it is, backfill it, and do a temporary repair, probably give it 24 or 48 hours to cure, and then they come out and do a full restoration. There's this stipulation with the DOT as to what that final restoration is going to look like and when it needs to be completed. A big pet peeve of mine is cuts in bike lanes, road openings in bike lanes. Bike lanes are mandatory to be used, and if you don't use it, you're going to get a ticket. So what's very frustrating to me is the city of New York makes it dangerous, right? If they're making you use it, make sure it's safe, or make sure your contractors who you're hiring to do your work, when they're done, are making it safe for cyclists. Because again, that little deviation in the road that might not be a big deal for a car causes people to crash. And I've had multiple people who fell because of either depressions in the roadway, collapses of backfill, if it's not backfilled and tampered properly, or if they don't get out there and do the final restoration timely, leaving in the dangerous condition. And then also proper width of modified bike lanes. Again, something that people don't think about unless they ride. The standard, the national standard for a bike lane is usually about 4 feet, and that's the best case scenario. But nobody rides a bike in a straight line. You turn the bike to balance, you have a deviation of a foot to either side or 6 inches to either side. So when you're riding through a very narrow space or a barricaded bike lane, there has to be a consideration of that deviation. And then you might want to consider whether or not you need an expert. That's an issue sometimes. There are experts out there who will help you understand good and acceptable construction standards, road safety standards, things like that. All right, so the first thing I say when you're investigating a street defect is photograph it as soon as possible, because these conditions are transient. It could be ongoing construction, and it might look one way on a Wednesday and very different on a Friday. So get out there as soon as possible. FOIL, I just talked about. Identifying the proper parties. You know, the easiest way sometimes to identify who's doing work is simply send your investigator out there or go out there yourself and get a license plate. Run the license plate. I now know who that contractor is out there. There are also markings on New York City streets. Colors are very important. Certain colors indicate certain type of services, gas, electric, cable, are painted different colors. The street plates themselves, potholes, plates. You know, we all see street plates for temporary openings in New York City streets, those big steel plates that you drive over. Again, that's something that's not a big deal when a car hits, but it can be really dangerous if it's in a bike lane. There needs to be proper ramping, which is basically kind of tapering that angle of attack as you go over the speed plate. But how do you know whose speed plate that is, or speed road plate that is? It's going to be welded on there. There should be a marking. For instance, what's MGO is a great example. MGO on a plate is Manhattan Gas Operation. That's Con Ed's gas operation. It's a good sign that Con Ed is out there doing the work. If you ask Con Ed, they'll tell you people steal their plates. It doesn't mean definitely because it says MGO, it's theirs. That's a defense to that. But there's certain things you're going to be looking for. All right. Okay, the 12-inch rule. It's not a dirty thought. Okay. The 12-inch rule is a rule in the city of New York that requires contractors or anybody who makes a cut in a city street or puts any kind of manhole or plate or anything else like that is required to maintain the area around that installation, the vault, the street plate, anything like that has to be maintained within the 12-inch parameter to be flush and even with the city street, and also make it for safe to ride over. And that includes not just the device or the plate itself being level, but the 12-inch perimeter around that as well has to be flush and level. That's the 12-inch rule. And again, that applies to the city of New York or any private contractor that cuts into a city street. Now, I was talking about modified or changed bike lanes. Here's an example. This is a construction site. I believe it's on First Avenue, if I remember correctly. And in order to do the work, they actually closed the sidewalk and they modified First Avenue to create both a pedestrian pathway and a bike pathway around the construction site. And these barricades are movable here. So during the course of the construction, in order to get equipment or vehicles in and onto the construction site or to make deliveries, they would move the barricades away. So I can almost guarantee you when they moved the barricades away, they're never being put back into the same exact location. And in one particular morning, a cyclist was traveling through there early morning on his way to work at a hotel, and they had just made a delivery, and they narrowed that bike lane well short of 4 feet, which is the mandatory length. So he comes around, and I don't have the approach picture, but it's a pretty sharp turn. He comes down First Avenue, goes over the intersection, it's about mid-block, and it makes a sharp right turn out into that construction lane or into that bike lane, and then a sharp left back into the bike lane, and it's a pretty tight turn. And he's traveling down there, and as he's going into that lane, it narrows. His left handlebar hits the barricade. He falls, fractures his shoulder, and is on his second surgery. Again, the people setting up that barricades have to remember that it's a mixed-use location and that there needs to be proper width length for cyclists in order to navigate that. And again, a violation of their own, going back to the records I was talking about, violation of the own standards, ordinances. So there's a permit to close that street, right? And one of the permits is you create a safe bike lane and you maintain that safe bike lane. That's a requirement in order to close the street. And here they violated that ordinance by narrowing the bike lane, causing the injury. This is another example. This is Kent, where they were doing some work over by one of the parks over there. And this was a 2-lane bike lane that was closed during the course of the construction. And this is a proper way to set up a closure of a bike lane. There's a flagman in the bike lane slowing bike traffic as cars are entering the bike lane because they can no longer use the roadway. And for my client, that's what should have been there. the week before when he encountered a Con Ed truck entering that bike lane head on at him because there was no flagman either stopping him or stopping the Con Ed truck. So there are, stipulations to a street closure that require the proper placement of flagmen. And you can see here, these trucks are taking over the entire bike lane. Actually, this truck's taking over the entire sidewalk too. So you need to make sure, if they're going to close the street, that it's done properly and safely and within the guidelines of the city of New York. All right. We all love dogs, right? You can always get a laugh from a puppy. All right. So dogs and bikes. Usually when I think about dogs and bike cases, it's usually the suburbs, and it's somebody riding a bike through a neighborhood and gets chased by a dog. Dog grabs onto their ankle, they fall and crash. The case I'm going to talk about is not. It's Central Park. So what am I, in 3 cases in Central Park? So what's the rule of this lecture today? Stay out of Central Park on your bike? All right. So this is Dorr versus Goldsmith. So Miss Dorr was riding her bike on a nice day in Central Park, on the Central Park's loop, when she saw a man holding a dog on the right-hand side of the road. His girlfriend was on the left-hand side of the road, and the girlfriend called the dog over, "Come here, Spot," whatever the dog's name. Dog runs across the roadway into the path of the cyclist. She hits the dog. Yes, the dog is okay, because I always laugh. I represented a highway patrolman who was a mounted New York City policeman, and he was on his horse on 72nd Street, wherever it was, and he and the horse got hit by a car. And the first question, it annoyed him. Everybody's like, "Oh my God, the poor horse." He's like, "The horse was fine. I broke my arm, but thank you for asking." Right? So, yeah. So here, as far as I know, the dog is okay, and the dog is not a named defendant either. All right. So the dog runs into the path of the bike, and she sues Goldsmith and the girlfriend based upon negligence, right? And the negligence theory was that you were negligent in allowing your dog, not even getting to leash laws or anything else like that, but you were negligent in allowing your dog to run across the path of Central Park where there were cyclists. And the defendants moved for summary judgment to dismiss the case. And it's granted and goes to the appellate division, who affirms the decision. So ownership of animals in New York State is based upon strict liability, right? And they applied the theories of strict liability, which are typical to a dog bite case, in this circumstance. And New York State does not recognize negligent ownership of an animal. They recognize strict liability through the act of a vicious animal or prior notice of a vicious animal. So typically in a dog bite case, the issue is whether or not the owner knew or should have known that the dog had bitten somebody before, and there's proof, either by a neighbor or by prior bite, of prior vicious propensities of that animal. And what's interesting about this case is that the negligence here was not based upon any kind of vicious nature of the animal, but the mere fact that the animal just had run across the street. But the appellate division said, no, the standard for us on any ownership of an animal is still that prior vicious nature of the animal. So the standard for the plaintiff on this case, even though it had nothing to do with a bite, is that the owner knew or should have known of the animal's vicious propensity. Again, strange, because it had nothing to do with a bite or any viciousness. And that the vicious propensity, the meaning is a propensity to do any act that might endanger the safety of the persons or property in any other given situation. So in a strong dissent, a really strong dissent, saying it's virtually impossible to prove a negligence case with a bicyclist when they run into the path of a bicyclist unless you could prove that this dog was vicious. Doesn't make a lot of sense, but this is presently the law of the state of New York when it comes to animals. So the dog gets to stay in the park. All right. Anybody have any questions? I have a few more minutes. No, I covered everything? All right. Yeah. Oh, sorry. Yeah, please. So the vehicle and traffic law within the bike path of the city of New York? Well,
I'm talking not a bike lane, but like a private or separate bike path.
Yeah, so like to give an example of Central Park. So Central Park, one of the issues...
Along the Hudson River.
Yeah, the Hudson River Trail. There is no bike lane, no law that I know of with regard to cyclists that I could think of in terms of either mandatory use of that bike lane. The big issue you see on that's a dangerous bike path. It really is. And what's dangerous on that bike path is bike-on-bike crashes, because the number of cyclists, and that route is where most people go. If you're not going to train in Central Park, if you're a triathlon or biathlete and you want to do a real extensive ride, most people are riding that path up over the George Washington Bridge, the 9W, Bear Mountain, where the real training begins. But the Hudson River Trail is your way out of the city, the safest way out of the city. So you have some pretty aggressive professional riders on that path. So that's one issue. And those parking lots, the ferry terminal coming in and out of there, there's a horrible story about a doctor that was killed there about 4 or 5 years ago. There's the DOT tow lot over there, and a DOT tow truck was coming out of there. So you have those intersections where people don't see cars coming out or don't expect cars coming out from the water side. So they're real dangerous. In terms of any obligation that I could think of in terms of the use of them, meaning is it mandatory to use them or speed? Is that what your question is?
Well, just what do the vehicle and traffic laws that in any way apply to that,
Yeah.
that arrangement since they're,
Yeah. I think the most applicable traffic laws for those are going to be those for vehicles
okay.
versus those for bikes. Yeah, but it's a real dangerous path. In combination of that and rollerbladers, or anytime you put rollerbladers, runners, cyclists, I have a friend of mine who broke her leg twice. Once on her bike, and then finally was feeling better, got on her rollerblades, and she got hit by a cyclist. So, on the Hudson River Trail. So it's a tough place. Yeah. Any other questions? No? All right. Anybody use city bikes? A couple of city bikes. All right. There, when I saw city bikes coming out, I'm like, wow, this is going to be a whole another area of law for me. It's not. It's amazing that city bikes have, all the naysayers, it's actually been an incredible program. There has been not one single fatality involving a city bike since it launched. Historically, bike share programs, I think Barclays, which is London's bike share program, which has existed for, I think, 5 or 6 years prior to City Bike, had its first fatality last summer. Alta operates down in DC with Capital Bike Share. They have not had any fatalities. It's an incredibly safe program. The claims that I have seen involving City Bike have been people tripping over the stations. That seems to be the most dangerous thing. There is one case that I know of where a man from Connecticut was riding the bike back into the City Bike station, and there was a parking stop, I guess, placed there to keep cars from backing into the bikes, and it wasn't marked properly, and it was nighttime, and he hit that and got very severely injured. He flipped over the handlebars and that. What I foresee being an issue, and I'm involved in one case right now involving city bikes, if anybody's really been following what's going on, the company that makes city bikes, Bixie, up in Canada, is in bankruptcy. Alta is having its own financial issues right now here in New York. That's why Relate is looking at buying them. And the ability to repair and maintain bikes is becoming an issue. All the seats are cracked. And I'm involved in a case regarding, I don't want to get too much detail, but regarding a defect in the bike itself because they're not being repaired properly or repaired timely. It's a system that requires users to tell City Bike when there's problems with the bike. So if you have a flat tire, missing chain, you put it back in the dock, you push the button, and City Bike's supposed to, it locks the bike until City Bike comes out and picks it up and repairs it. And right now there's something like $1,300 bikes sitting in Brooklyn waiting for parts and repairs. I don't know if the delay in parts and repairs is due to Bixie, who makes them, being in bankruptcy and not being able to get them parts fast enough, or just City Bike not keeping up with the mass need to maintain the bikes. But some of the bikes are becoming negligent, are becoming dangerous to ride, so I would just double check your bike before you get on it. Make sure the fenders aren't dislodged, make sure the brakes are working, make sure the tires are on pretty good, because it's a system that requires users to notify City Bike about a defect. And if somebody puts it back and doesn't tell somebody about it, and it's not an obvious defect, it can be dangerous. So I foresee not, I do have people who have been struck on them, but it's 1% versus the number of people who are using their own private bikes. But I would just kind of, for my own, just your own caution for you, just double check a City Bike before you get on it, make sure it's all in good shape, and double check it before you get on there. All right. How are we doing on time? All right, we're good, or? All right, guys. Thank you.